Well, our top story at this hour. In a landmark ruling, the Supreme Court today held that a Muslim woman is entitled to file a petition for maintenance against her husband under Section 125 of the CrPC, that's the Criminal Code procedure. Now, the bench dismissed a petition that was filed by a Muslim man's plea against the direction to pay interim maintenance to his divorced wife under Section 125 of the CrPC. The court held that the Muslim Women Protections of Rights on Divorce Act will not prevail over secular law. A Muslim man had approached the Supreme Court to challenge a family court's direction to grant interim maintenance to his divorced wife. Now, during the first hearing, the Supreme Court agreed to consider the legal point and question whether a Muslim woman is entitled to uphold the petition under Section 125 of the CrPC. Now, this, in fact, is a landmark ruling that we're now bringing to you. This came out today from the Supreme Court, where it held that a Muslim woman is entitled to, in fact, file for petition for maintenance against her husband under Section 125 of the Criminal Code of Procedure. Justices Nagaratna and Masi delivered separate but concurring judgments. Joining us on the broadcast, Anuja Petia, advocate on record, Supreme Court of India. Very warm welcome to you. Many thanks for joining and speaking to News9 Live. Very quickly, getting a sense of how you're looking at this particular statement where Justices Nagaratna say, we're dismissing the criminal appeal with the conclusion that Section 125 of the CrPC would be applicable to all women and not just married women. For the benefit of the viewers, can you put this in context, please?
Yeah. Hi, Kabir. So this is a landmark judgment by the Supreme Court, which has reiterated and expanded what Shahbano judgment had done. So you would know that there was a landmark judgment on Muslim law, Shahbano, where Section 125, which is the section under which maintenance is claimed by any dependents of a husband, that section was extended to Muslim law as well. And after that, after the Shahbano case had come, the verdict of the judgment was somewhat diluted by the Muslim Protection Act 1986. And there was some uncertainty about which law would prevail, whether the maintenance can be claimed under the Muslim Protection Act 1986, where it can be claimed only for a certain period, that period, or whether it can be claimed under Section 125. So the Supreme Court today has said it emphatically that Section 125 would prevail over the Muslim Protection Act. What that means is that any woman, irrespective of her religion, can approach the appropriate court and file a Section 125 maintenance petition. That's one thing. Secondly, it's a very important statement that Justice Nagaratna has made, that it extends to all women, whether they are married or not, which essentially means that you must have seen a judicial trend of courts recognizing rights of unmarried women, even though even if they are living in a live-in relationship. I think that sort of principle has been extended here to Muslim women as well.
All right. And from your word with the Muslim community, particularly the Muslim women, is this a welcome decision? How are the local community and the people that are actually affected by this order reacting to it?
So see, Section 125 is part of CrPC. It applies to all women. CrPC cannot discriminate on the basis of religion. So the only question that was up for consideration was, would CrPC prevail over the special act? And the answer is very simple, that yes, it will, because it is a secular law. So it is beneficial for women. You can apply for a 125 maintenance now before court, which is very important for a lot of women when they get separated from their husband. And the maintenance over here is not dependent on the iddat period. So the quantum and the time increases.
Anuja, from how I'm looking at this, on the Libra scales, essentially you're weighing personal laws and, well, secular laws that are bestowed upon the entire nation. How do you see this particular balance game playing out? Do you think there are going to be negative repercussions because of it, or could be?
See, I'm certain there would be. It's always been a contentious issue, balancing of matrimonial rights of women with personal religious law. So it's always been a contentious issue, and this balance has been developed by courts over time through various judgments. And I think this is another step towards balancing. As time goes on, we need to recognize that the rights of women have to be equal. They cannot be different basis the religion that they belong to. And the thing is that what the judgment today has done, it has not excluded the Muslim Protection Act 1986. If a woman wants, she can apply for maintenance under that particular act. If she wants, she can apply for maintenance under section 125. So it's simply given her a choice, that which legal provision would she want to go ahead with to apply for maintenance.
I'm reading specific portions from the order that has been put out. Part C of the particular, petition that has been put out by Senior Advocate S. Wasim A. Qadri, appearing for the petitioner husband. He's read following contentions, and I'm just going to read out point C and try to understand what you make of it as well. It is a settled position of law that special law, the Act, shall prevail over general law, that's the CrPC, of language of the Act being clear. There is no reason for the court to go beyond. It must simply give effect to what is stated in the Act.
Yes, so that is a principle of law, that special laws have an overriding effect over general law. However, there is another contesting principle of law, which is that any beneficial legislation has to be interpreted widely, and its ambit has to be increased by the courts. So there are two principles that are competing here.
And has that happened here? My apologies for intervening. Justices Nagaratna and Justices Masi, have they done that for the social benefit, benefit? Socio-economic benefit?
Yes, absolutely. Section 125 is something which is there for the benefit of women and dependent children. So what they have done is given precedence to this principle, I believe.
All right, all right. Well, on that note, Anuja Pethia, many thanks for joining with us and helping us out with these particular details. It seems like this is certainly a landmark ruling. The Supreme Court has today held that a Muslim woman is entitled to file a petition for maintenance against her husband. And for the finer print, well, with us was Anuja Pethia, advocate on record, Supreme Court of India. We're going to slip into a quick break here, ladies and gentlemen. Top stories and developments right on the other side. Keep watching News9 Live.